Hello people, what's up? So, I know most of you have been waiting for the amendments part to be discussed. There is nothing major. I know the document has around 59 pages. As I always tell you, they have given the amendments for the last 2-3 attempts put together. I think 3 attempts have been covered. That is June 24, December 24, June 25 and December 25. So let us imagine if you guys have already listened or if you guys have attended June 25 exam, then only this particular video is sufficient for you. Let us imagine if that is not the case, if you guys have attended my classes, then yes, only this one is sufficient. If at all you have attended the recent classes, that is, imagine you have attended even before June also, it's okay. Only this alone will be sufficient. Let us imagine if you have watched it before, then I will always suggest at least watch 2 amendments and go. So I've already uploaded on YouTube June 2025 amendments. Watch that. After that, come and watch this amendment, December 2025 amendments. Remember, always from amendments, you can always expect a score of around 5 to 10 marks. Which if you ask me, is it a good score? Answer is yes. So can I say in this, so 59 pages includes everything. So if you see the old file, I think it is around 2 hours, which has really good amendments. The delisting part and all had come. And the this one, the December part. So everything put together, that means 50 pages. And if you guys are able to watch all of this within say 4 hours, June and this one, and I can say you get 5 to 10 marks, then what more you want? Good only, no? Okay, so let us see these amendments for December 2025 and onwards. They have given a big list of all the charts and all. Okay, see, by default, what we will be doing in this particular video is December 2024, any amendment has come and onwards, we will be covering here. So December to around June amendments will be covered in this particular video. So by default, July 2024, this is before that. That means we have covered in June 2025 amendment. Understood? So done. Yes, sir. So what is this? May 21. No, this we have to do. What is this? SEBI has notified SEBI alternate investment funds, which shall come into force on the date of their publication. Why this notification relating to conditions for category 2 AIF has been substituted as. So some rule, some regulation has been substituted, it seems. What is that they are saying? Category 2 AIF shall invest in investee companies or in the units of category 1 or other category 2 AIF as may be disclosed in the placement memorandum. Explanation: category 2 AIF shall invest primarily in unlisted securities and or listed debt securities, including securitized debt instruments which are rated A or below by credit rating agency registered with board, directly or through investment in units of other AIFs in the manner as may be specified by the board. Now what is that they are telling you people? Earlier we had one conditions to be called as a category 2 AIF. Now that condition has been substituted, it seems. Now what is that? Now simple. Where can a category 2 AIF, where can the investor, remember this, the category AIF, category 2 AIF shall invest in investee companies, meaning companies, or in the units of category 1. So you can imagine like this, I can invest in companies, or I can invest in category 1 AIF, or I can invest in category 2 AIF as may be disclosed in the placement memorandum. What do you mean by placement memorandum? Using what document did the category 2 people, how did they get the money? They would have issued some document and they would have raised money, right? Like for example, offer document. So category 2 AIFs have issued a document to raise money, and that document we call it as placement memorandum. I've raised money. Now I can use to invest the money using this particular document. Whatever I've raised, I can use it in these 3 places. Explanation: category 2 AIF shall invest in primarily. Now I've said no, you can invest in companies. Which companies I can invest in? They have given you a clarification. You can invest only in unlisted securities and or see unlisted securities or listed debt securities, not equity. If it is equity, it should be unlisted. If it is debt, it's okay. It is even if it is listed. Including, I can invest in securitized debt instruments which are rated A or below by credit rating agency registered with the board. Securitized debt instruments means, people, you guys should have studied something called as asset reconstruction companies. Generally, if you guys remember, if a banks have bad debts and all, non-performing assets, they will sell it to few companies and they will take the money. And these companies will try to go and recover those debts. Now, the companies which are buying these non-performing assets from banks, whichever purchases this non-performing assets, which company purchases? The company which purchases these assets are called as ARC companies, asset reconstruction companies. Now, where are they getting money from? They issue something called as securitized debt instruments. Now, who can invest in the securitized debt instruments? So, they are issuing this instrument and they are raising money. Correct? Now, they are issuing these instruments and they are raising money. Now, the question is, who is investing in this SDI? They are telling you category 2 AIF can invest even in this SDI, securitized debt instruments. So, where and all they can invest? They can invest in category 1 now, investing companies. Specifically unlisted. Debt, if it is listed also, it's okay. And I can also invest in securitized debt instruments. That is what is this amendment. That's all. Simple. Okay, that was a Kutty amendment. I'll tell you where it is important. March 24 it is done. Okay, December 24. This is one amendment which we need to do. Now, what is that, people? If you remember, previously there was an amendment. What was that? People, technically we started from T+2 as our settlement cycle. That means if on a Monday, if I'm selling shares, money will get credited to my account on Wednesday. So T+1 Monday, plus Tuesday, +2 Wednesday. Now, people, amendment came, they made it as T+1. So if I sell it on Monday, Tuesday only I'm getting money. In the June attempt, there was an amendment. They introduced a new cycle called as T+0. And this was implemented for 25 companies as beta testing, meaning they wanted to check. So what do I mean by this? If you're selling it on a Monday, you will get money also on Monday only. Now, earlier it was for 25 scripts. Now they have increased this. That is what is the amendment. Now see here. The first one is as it is. So 25 scripts, whatever was there, it is as it is. Now this is the amendment. SEBI wide its circular dated December 10, 2024 enhanced the scope of optional T+0 rolling settlement cycle in addition to the existing T+1 in equity market. Okay. It is provided that the optional T+0 settlement cycle will be made available. Earlier was 25, no. Currently also it is optional only. But now we are testing it on top 500 scripts. How will we select the top 500? We will select it based upon the market capitalization as on December 31st, 2024. So the top companies, depending upon their market share, the top companies will have to follow now T+0 settlement cycle. The scripts shall be made available for trading and settlement starting with scripts at bottom 100 companies out of the aforesaid 500 companies and gradually include the next bottom 100 every month till the top 500 companies are available for trading in optional T+0 settlement cycle. The above list of scripts shall be in addition to the existing 25 scripts in the beta version cycle. Now, what do I mean by that, sir? They're telling you, people, what is that they're telling you? They made a circular in December 2024 and they said what? The top 500 companies, the top 500. So can I say the first list of top 500? So can I say like this? Let us do it from bottom to top. Let us imagine this is the bottom 100. Now this is the top 100. Meaning I'm talking like this. 100 from this is like another 100. That means what? 100 plus 100. This becomes 200. Here we cover 300. Here we cover 400. Here we cover 500. So I'm taking it in order. So now what they're telling you, see here. So whenever I'm counting the top 500 companies. So start from bottom, meaning the 401 to 500. That is the top bottom 100 in the 500 companies. And next comes 301 to 400. And next comes 201 to 200. 101 to 200. And next comes 0 to 100. Correct? Now 0 to 100 will come here. What are they telling you? First, the bottom 100 companies, you should start implementing. So first in 2025 June, what did we see? 25 scripts we did testing. Now they are telling the top 500, the bottom 100 companies of top 500. That is from 401 to 500, whoever are there. For them, they are telling you people, you will also start following this T+0 settlement from the next month. Now after 1 month, next month, now let us imagine Jan, they will implement. Feb 301 to 400 will implement. Like that people, by end of 5 months, the top 500 companies, everyone have to implement T+0 settlement cycle. Now you can ask, sir, first time we are seeing the top 100 being taken in an opposite way. We generally take it from 100 to 500, right? Where have we taken 500 to 100? Now people, for that they are telling what? See, remember top 100, bottom 100 and top 100. In top 100 people, the trading frequency will be way too high. The share capital is high. The number of shares is high. So if at all, let us imagine if there are any errors, the system, the stock exchange, we do not know whether we can handle this or not, because money should be credited in 1 day. Till today we were taking 2 days, 1 day and all. Now all of a sudden you are telling 1 day everything should settle. That means what? The entire system has to support for it. So to be on a safer side, what we have done, we have taken people bottom 100 so that the trading will be lesser when compared. Here the trading will be high. So you will get the time to learn your mistakes and then implement it on a full scale. That's why the logic of bottom 100 first. That is this amendment. Remember and go, may be important. I can say 3 marks. Clear? Okay. Next one, April 24 done. November 24 done. November 29 done. December 16 we have to do. Now where is this amendment? Securities market intermediaries. Okay. I've also added this in our material so that we will also understand. Now where is the amendment, sir? The amendment is this is where the amendment is, where we had something called as investment advisors, correct? We had something called as investment advisors. Where did that go? Research analyst. Investment advisors. Okay. So there are 2 amendments. One in investment advisor. Whatever you have read, this and all is there. Directly go to the amendment part. Now what are they telling you people? Amendment, it seems. What is that? We had seen something called as investment advisors. Now what do you mean by investment advisors? The definition was, it means any person who for consideration is engaged in the business of providing investment advice to the clients, or person or group of person includes a person who holds himself as an investment advisor, correct? Here you can expect a question. Now what they're telling you, this definition has been now changed, it seems. What is the new definition? Now this is the new definition. It means any person who for consideration is engaged in the business of providing investment advice to the clients, or other persons or group of persons and includes, this is the amendment, a part-time investment advisor or any person who holds out himself as an investment advisor by whatever name called. Meaning what? Now people, they have added a one more category of investment advisors. Now who are there? Let us imagine, now I am a teacher. Part-time I will teach. In the morning to evening, what I will do? I will give investment advisors. Now a person who is doing some other job and also managing the investment advisor role, you call such people as what? Part-time. Now people who are doing part-time are also added in the definition. That is, what is this? The definition of investment advice is amended, which as per amendment definition means advice relating to purchasing, advice in portfolio, whether written or other means of communication, benefit shall include a financial planning, provided that the investment advice given through, again important, what is that they're telling you? The investment advisor, they're telling you what? The investment advice given through newspaper, magazine, any electronic or broadcasting or telecommunication medium which is widely available to public shall not be considered as investment advice. They can ask you what are the people who are excluded from the definition of investment advice. Who are excluded? Let us imagine people, I become an investment advisor. Now what do? Tomorrow I will on my say for example on Instagram page, I will share people tomorrow an IPO is coming and say you guys can apply, and I will say people, let us imagine what is that, say for example Infosys is currently trading at 1500. It's a good price to buy for a short gain, 1600. I am just giving an advice. Now they are telling I will not be considered as an investment advisor in Sims. Now I'll tell you the logic also why we will not be considered as investment advisor. The logic behind it means people, it's very simple. The logic here is, if at all you're an investment advisor, you're always giving a personalized financial product for an investor. Meaning now you come and ask me, sir, can you please advise me? I have 10,000 rupees. How can I invest? Now what do? I make a portfolio specifically for your purpose. Now people, this is called as personalized investment plan. Now I will be called as investment advisor. When I give it on a public medium, people, I am not specifically catering to any particular person. So I cannot be called as an investment advisor. Then what will I be called as? I will be called as a people research analyst. A person who just gives a call. And I'm not giving you a purpose of self or a personalized investment care. I will be called as research analyst. If I give you a personalized care, I will be called as investment advisor. That is what they are telling you. Anywhere, if you give your advice as a newspaper, magazine, any electronic or broadcasting, Instagram or telecommunication medium, Telegram, WhatsApp, which is widely available to public, everyone, it shall not be considered as investment advice. And not only that, see, provided further that a trading call, meaning what? Buy at 1500, sell at 1650, make that 150 rupees profit. Even this cannot be considered as investment advice, it seems. Why? Because as I told you, it is given it as a vague thing. We are giving it to the public. I am not doing any personalized investment plans here. Clear? Next one, sir. Deposits. An investment advisor shall maintain a deposit of such sum as may be specified by the board from time to time. Remember people, what is this? The deposit shall be maintained with a scheduled bank marked as a lien in favor of a body or body corporate recognized by the board, that is SEBI, for the purpose of administration and supervision of investment advisors in accordance with regulation 14 of these regulation, provided that such deposit shall be available for utilization in case investment advisor fails to pay dues emanating out of arbitration and conciliation proceedings under the online dispute resolution mechanism. Now what do I mean by that people? Nothing but people, earlier and all we had something called as capital requirement. Now that capital requirement is substituted with the deposit requirement. Earlier we had capital requirement, now that is replaced with deposit requirement. Now what is that? Anyone who becomes an investment advisor, you need to maintain a mandatory deposit in favor of a body or body corporate recognized by the board. SEBI will tell you You have to make a deposit in the favor of such a body. Whomsoever I tell you, you have to make it in their favor for the purpose of administration and supervision of investment advisors. Now, what will we use this money for? Let us imagine people. Someone files a online dispute on you. They are not happy with it. You guys went to arbitration. You are saying that you will not make the payment. You have made some mistakes. I am telling you to make the payment. You are not making the payment. Now people, SEBI will use this deposit money towards the settlement of these disputes, which you had to rightfully pay. So that is the amendment. Earlier we had capital requirement. Now it is replaced with deposit requirement. Now we will place it with people, SEBI. Technically, person authorized designated in that favor. I have to create a lien. If at all there is any dispute, I can use it towards that. It will be utilized in the case of investment advisor fails to pay dues. Emanating means arising out of arbitration and conciliation proceedings. Clear? Okay. A new clause is inserted under the general obligation and responsibilities of the investment advisor. We had something called general obligation of this one. Here there is one more point added, it seems. Now what is that one more point? The one more point is an investment advisor who uses ChatGPT macha. They're telling you, irrespective of the scale and scenario of adoption of such tools for servicing its clients, shall be solely responsible for the security, confidentiality, integrity of the client's data, use of any other information or data to arrive at investment advice based on output of AI tools, everything for time being in force. Now, what do you mean by that, sir? Let us imagine people using ChatGPT. I am giving you investment advisors. Using ChatGPT, you told me, no, sir, can you please give me a good investment advice for 10,000 rupees? I say, Mr. A, aged 21 years, earning 50,000 rupees, wants to park his 10,000 funds. Can you please advise where and all this can be parked? Diversification. Now, whatever it tells, I tell you. So people, if someone is using artificial intelligence, then they are purely responsible for the client's security, for the client's information, confidentiality. I gave away everything. Integrity, meaning truthfulness. And if I give you any calls, meaning your investment advisors using AI tools, people, I am personally responsible. And only then I can give it to you. That is what they're telling you. Next one, regulation 20 relating to appointment of compliance officer is amended. Now, simple people, if there is any non-individual investment advisor, they will have to mandatorily appoint people, a compliance officer or an independent professional who is again CA, CS, CMA or member of any other professional body which is specified by the board, that is SEBI. So I have to mandatorily appoint a compliance officer or any other professional, CA, CS, CMA or any other professional as specified by SEBI, provided such a professional holds a relevant certification from NISM. This is something which is conducted by SEBI only. On stock market awareness, you have to clear that exam. And if someone has cleared that, then you can appoint him as may be specified by the board, who shall be responsible for monitoring the compliance by the investment advisor in respect of requirements of the act. Meaning what, sir? So imagine if at all the investment advisor is a non-individual investment advisor, meaning he is a company. All the compliances to be taken care by this person, someone called as compliance officer or this professional, they will have to take care of all of those things. That is what is given in this amendment. Got a fair idea now? Yes, that is what is given here. An independent professional of this regulation is appointed for monitoring compliances. The principal officer shall submit an undertaking to the board recognizing to the effect that the principal officer shall be responsible for monitoring the compliance in respect of requirements of the act, regulation, notifications. So what is that, sir? Whoever is the main authority who appointed us, they will have to file and say to the board, sir, we will take care of all the compliances, you don't worry. So this is the amendments that has been done in investment advisor. Same cut copy paste people is also put in research analyst. What is that? They have also added part-time person here. Same to same. Now, what is the difference between, few people will have a doubt, what is the difference between research analyst and investment advisor? Research analyst is, as I told you, I will do my research and I'll just put it in the public domain. I will never cater it to any specific audience. I will never give a personalized trading suggestion. If I do that, I'm called a research analyst. If I do a personalized trading suggestion, I'm called an investment advisor. A new definition of research services is inserted, which means the following services provided by the research analyst: preparation or publication of research report or content of the research report. Now imagine I do some research of charts. I can publish that. I'm a research analyst. Providing or issuing research report or research analysis. I'm a research analyst. Making buy, sell, hold recommendations. People buy Infosys, sell Infosys, hold ITC for long term. Giving a price target or stop loss target. People enter buy Infosys, sell it at 2000 rupees. Offering an opinion concerning public offer, IPO, should you buy or not buy? Recommending model portfolio. People technically keep 40% in equity, 20% in debt, 20% in FDs. I'm telling what is a model, meaning ideal portfolio. Providing trading calls. Trading calls is again that only. Buy, sell and all of that. So they have added this also, and this will become what? Services offered by the research analyst. They have added it themselves. Okay. Again, same thing, people cut, copy, paste. Capital is now substituted with the deposit. With the SEBI available for utilization in case fails to do emanating arbitration. Cut, copy, paste. Done. Next one. New clause has been inserted in general obligations. Now what is that, sir? Same thing. Artificial intelligence, solely your responsibility. Cut, copy, paste. Next one. Again, compliance officer. Compliance officer independent. Cut, copy, paste. Same. Nothing new. Hello. Okay. That's all. See, that's the amendment. There is one amendment here. What is that amendment? In credit rating agency, there is an amendment. The third amendment. Now, what is the third amendment? Now, see here. You guys know what is called as credit rating agencies? Whenever someone comes for an IPO, someone issues a debt, or you guys would have studied in company law. If you guys are using public deposits and all, a credit rating agency comes and says that whether this company is a safe company, if you invest your money, whether you will get back your money or not, all those claims will be made. Now one company will come and say the grade of this particular company is A+, that means a good company. B, it can be bad. C, can do better. D, if you invest you will die. So someone is giving you all this rating, no? Now people, what and all are the other activities these people can do? They could do monitoring agency role also, if you remember. Now they have added one more role for credit rating agencies. Now what is that one more role? Now that is here. Has inserted a new chapter for the credit rating agencies, that is nothing but past risk and return verification agencies, specifying that the activity of past risk and return verification agency may be carried out by a credit rating agency. The credit rating agency can carry out a new activity, it seems. What is that called? Past risk and return verification. Now what do I mean by that? Simple, people. Now imagine I'm an investment advisor. Who? Me. I'm going and telling my client, you know what? For the last 3 years, all my clients have been earning minimum of 40 lakh rupees. Minimum return I'm able to give is 40% every year. Now like this, I'll make any claim. Research analyst, he will make his claim. Hey, what is the guarantee that this is true, da? So now what they're telling you, tomorrow, if you're a research analyst, if you're an investment advisor, if you guys are making that claims, you cannot make that claim if it is not verified by anyone. Now today, if I have to make a claim that I am giving 40% return every year, Now they're telling me, people, I should have actually given that and someone has to check it. Who will check it? Now that rating can also be given by people, credit rating agency. That only is called as past risk and return verification. Have you actually given the return? 40% return. Were you able to give? Who will do it? Credit rating agency will do it. It's clear, that's what they're given here. See, with the approval of SEBI on such terms and conditions, the past risk verification agency shall engage a recognized stock exchange as a past risk and return agency data center on such terms and conditions as may be specified. Meaning my name will be reflecting on the stock exchange's website. And not only that, sir, they have told the provision of this chapter 3C shall be applicable only to, now who and all should get it done? Investment advisors, research analysts, algo providers, empaneled with a recognized stock exchange and intermediaries permitted by SEBI to provide the services of investment advisor, research analyst and algorithm trading. Algorithm trading is nothing but people, system based trading. There will be formulas. The system will tell you when to buy a stock, when to sell a stock. A few companies give you such type of services also. So these three people should mandatorily follow this now. Yes, so shall be permitted to make claim of returns or performance in the form which have been verified by a credit rating agency recognized SEBI to carry out the activity of a past risk and return verification agency. So if they have to claim, these people have to verify. This is the third amendment. Clear? Any doubts? So technically there are what? 3 amendments in this particular case. The 3 amendments are where people, actually there should be one more. 1 second. Credit rating we did. There is one more people, a generic amendment. What is this? Responsibility for the use of artificial intelligence. Any person regulated by SEBI who uses AI and machine learning tools and techniques either designed by it or procured from someone else, irrespective of the scale and scenario, even if you're doing for 10 rupees or 10 crore of such tools for conducting its business and servicing its investors, you're using AI tools or machine learning tools, then you shall be solely responsible for the privacy of the investors, their security, their integrity, including their data maintained in fiduciary capacity, because our data is with us. Anything happens tomorrow, it is your responsibility. For the output arising from the usage of such tools and techniques, it relies upon or deals with, and for the compliance with applicable laws in force. What do you mean by that, sir? Meaning I've given you trading calls based upon AI tools. I am responsible for that. Now, because I'm using AI, any other law that will be applicable to me, I will have to satisfy that as well. For example, just now we saw in research analysts and investment advisors. So I have to follow that as well. So this is the 4th amendment in this particular chapter. So remember and go. Investment advisor, research analyst, credit rating agency and AI. Simple. Okay. That is what it is. Next one is IFSC. Okay. IFSC is simple, people. Nothing but they have added one topic in IFSC. Now, what is the topic, people? Nothing but which was already there, nothing new. Now, what was already there, sir? We had already, people, something called as what do you say? In securities market, we had 3 things, sir. Something called as no action letter, interpretative letter, and confidentiality request. If you remember. Now, what do I mean by that? Let us imagine, people. Company A is Company A is trying to take over Company B. Now I have some, I'm trying to find a rule. I'm finding a rule very difficult to understand. So Company A, what will they do? Company A will write a clarification letter to SEBI. SEBI, I'm not able to understand whatever this rule is. Can you please help me to understand it? Now, SEBI people will reply to you in one letter called as interpretative letter. They will give you a letter how to interpret that particular law, how to understand that. Now, sir, to understand that, people, you have to give all the information to SEBI first. Now, what if SEBI, based upon the information I have given, what if there is any non-compliance? What if SEBI takes any action against me? SEBI people, I will request, please SEBI, don't take any action against me. I am giving you all the details I have. Now, that is only called as no action letter. Sir, now whichever documents we are filing with SEBI, all of these people are public documents. Anyone can download. I will ask SEBI, please don't tell it to anyone because we have not told it to anyone else. We are not sure whether it is going to happen. So please don't put it in the public domain. Now I am asking for the third request. It is called as confidentiality request. The maximum time I'll get confidentiality request, people, the confidentiality treatment, the maximum you'll get is 90 days. Cut, copy, paste will apply to IFSC. There SEBI will give, here who will give? It will be given by IFSCA. That's all, that's the amendment. Whatever you guys have seen there, cut, copy, paste will apply to IFSCA. Now if you guys have any problem in IFSC, you guys will file interpretative letter to IFSCA. Confidentiality request to IFSCA. No action letter to IFSCA. For only companies listed in IFSCA, not everyone. Understood? That's the amendment. Next, April 20th. Okay, I've sent the old one. Okay, nonetheless. Now, what is this, sir? They have issued something new, it seems. What is that? Repealed the old regulation and introduced key changes, including an increased validity period of 12 months for PPMs from 6 months. So, first amendment, what is that, people? Increase in validity. Increase in validity. First it was 6 months. Now it is increased to 12 months. That's the first amendment. Of what? Increase in validity of PPM. Yes, sir. Increase in the validity of PPM. Okay. PPM stands for Private Placement Memorandum. Yes, sir. Okay. Next. And a reduced minimum corpus requirement. The second one is corpus. Minimum corpus requirement of USD 3 million down from USD 5 million. First it was, people, $5 million. Now people, they have reduced it to $3 million. For venture capital and restricted schemes. Schemes recorded or extended under the 2020 regulation may operate under the new regime. A one-time opportunity is being offered to the fund management entities to seek an extension of the PPM of venture capital scheme and restricted scheme whose validity has expired before Feb 19, 2025. A one-time window allows expired PPMs to be refiled within 3 months subject to the conditions. The next one is, people, extension. Now, this is the amendment. Now, what is this amendment, people? It's nothing but they are trying to bring an amendment. The old, the key changes include the increase of okay. Now, what is this, sir? Now, see here. Now, people, anyone who manages funds. Let us imagine, people, there is one venture capital fund. Now, venture capital funds, they take money and they will invest in some good companies or a prospective places. Now, what they are telling you, these venture capital funds, where are they getting money from? They will also collect the money from using some source. Now, first of all, who can set up this management funds? They're telling you, people, earlier there was stringent requirements of corpus. You should have at least minimum $5 million. Now, to start this, people, today, you just need a corpus of, people, $3 million. If you have it, you can start. So, $2 million they have reduced. Okay, now I've set it up, sir. Now, I should get money. What will I do? I will issue a document. The document is called as PPM, Private Placement Memorandum. Taking this, people, interested people will invest money into my company. Now earlier this validity was people maximum 6 months. Now they have said no, you do one thing that will be valid for 12 months. You raise enough money you want. Sir, what if I had raised, I have issued PPM before this amendment? The effective date of this amendment was people February 19, 2025. Let us imagine. If at all whatever PPM you have issued has been expired on February 19, 2025. That means you have issued on December, in the past. As on February 19, 2025, your PPM is expired. Imagine it expired in January. It was expired in December. They're telling you people within 3 months from Feb 19, 2025, within 3 months, write a notice and they will increase your, your PPM again to 12 months. Your validity to 12 months. So if you file an extension, sir, please give me another chance. My PPM, I thought it was 6 months under old thing. It is done. Now it is 12 months. Please give me an extension. Now they will provide you an extension, people. See, a one-time window allows expired PPMs to be refiled within 3 months, subject to condition. And for this, no processing fees also is charged. And they will increase it, or they will allow you to increase to such period as they may allow or as they may deem fit. This is the amendment. Remember these three and go. That is the amendment. Here, done. December 2023, Feb 2024, May 2024, done. March 2025, applicable to SEBI ICDR, rights issue, convertible. People, this is an important amendment. Now, whatever this is an important amendment. What is that? ICDR. Now, what does this amendment say? I have tried to classify it. I have tried to take it as simple as possible so that we understand this particular thing. So, SEBI ICDR Amendment Regulations 2025. Now, what have they done, people? There is an amendment, people, in rights issue. If you remember earlier, ICDR for rights issue, when was it applicable? If you remember, 50 crore or more. What if it was less than 50 crore? If a listed company was doing rights issue, for that, people, ICDR was not applicable at all. Now, people, what they have done, that 50 crore limit is removed. So today, even if you are doing 1 crore of rights issue, people, if you are a listed company, then ICDR is mandatorily applicable. It's an important thing. You can expect a question. Okay, see, when do these amendments come into picture? They're telling you, SEBI notified these amendments on 3rd March 2025. For rights issues, these amendments will start 31 days after publication. This was the date of publication. So it will come into picture 31 days after the date of publication. Imagine, people, if at all your rights issues was passed before the amendment, then this amendment will not apply to you. Follow whatever you want. This amendment is prospective in nature. Whatever are the new rights issues which is not yet passed, which is not yet approved by the company. So for them only this particular thing will apply. Applicability of ICDR, earlier see 50 crore or more. Only for that it was applicable. Now, people, they have removed this limit. That means what? Regardless of the size, ICDR is applicable. IPO eligibility, outstanding convertible securities. Now, what is that, people? Earlier there was a rule. If at all there is any outstanding securities, meaning what? You have issued security, but equity is not yet given. You have given something, like for example, say convertible debentures. It will get converted to equity one day or the other. No, they could not go for a rights issue. Like that, any security you have given, which has a right to get equity, if it is not yet converted, you could not go for rights issue. Now, on that, there is an amendment. What is that? If any convertible securities are outstanding, IPO was not allowed in the past. Now, the new relaxation, this rule does not apply to the stock appreciation rights. Now, whatever is SAR, you guys have seen in employee share benefit scheme. So, nothing but it's a right given to the employee. Today, we identify you. Probably after 2 years, if you are worth, we will give you shares. Now, today it is convertible only, no? If you stay with us for 2 years, then you may get equity, no? So technically it is still convertible, right? They're telling you it's okay. For this, it will not be applicable. Even if it is outstanding, you can still go ahead with the rights issue. Provided SARs were given under a valid employee SAR scheme. It should be as per the scheme. SARs are fully exercised into equity before shares before filing red herring prospectus or prospectus, meaning people, before I file the prospectus or letter of offer, technically today what we file is draft offer documents. I mean, we'll see letter of offer, we call it as. So before filing that, if at all I have done, what is this, what is that? Before, if I have issued a letter of offer, prospectus, draft prospectus or red herring prospectus, if at all you remember eligibility requirement, if at all there was any convertible securities, we could not go for IPO. Now here they are telling you, you can still go for IPO if SARs are pending, if it is outstanding. Provided as on the date of filing, the draft prospectus, red herring prospectus. Now first what we do, we file a DRHP to stock exchanges and SEBI. Even now if your SAR has been issued, but still not, equity is not yet given, it is still okay. Finally you will issue RHP, red herring prospectus, finally. When you are giving it finally, before that people, if you have issued equity to that employee, sufficient. Now that's a relaxation, that's an amendment. Clear? Okay. Next one, compliance officer requirement. Now people, you must appoint a company secretary as a compliance officer as per these regulations. What are these regulations? Nothing but one is IPO, one is FPO, one is IPO of IDRs. Next one is rights issue of IDRs. For all these people now, appointment of compliance officer is mandatory. That's one of the amendment. Next one, draft offer document. They're telling you, you have to put the draft letter of draft offer document people in the public domain. At least you have to post it for 21 days it seems for their comments. Now where will I post it, sir? I will have to post it people in the website of, on the website of the company, on the website of SEBI, on the website of stock exchange where I am listed, and all your lead managers, whoever is doing, if they have any concerns, they will come back. Now, when am I doing this people? Before you go for an IPO, draft offer document, remember, before you go for a public offer, I'll have to first give it. This is not rights issue. This is public offer. Before I go for it, I will first publish it in the stock exchanges website, my website, SEBI's website for your comments. If you guys have any comments, please come back with it. Okay. Price band or floor price announcement. Meaning what people? I have to clearly tell no. If you guys remember book building issue, my prices, sir, I'm trying to consider 200 to 210. I have to advertise it somewhere, right? That is only called as what people? Floor price or price band at least 2 working days before the issue opens. I have to tell it now. Okay. I have to publish in a pre-issue advertisement and price band advertisement in the same newspaper wherever I had given public announcement. Again, I'm talking about IPOs only. Okay. Pre-issue advertisement after filing RHP prospectus. What is this, sir? After filing red herring prospectus or prospectus with ROC, I have to give something called pre-issue and price band advertisement. This is nothing but people. I will clearly tell. Earlier it was optional people. Now it is mandatory. I have to clearly tell what is my price band. I have to give it as an advertisement in the newspaper that people, we are coming for an IPO on so and so day. The price band will be 200 to 210. Next one, reporting of promoters transactions. Now what is it, sir? During the issue period from filing draft offer document till the issue closes. Now you would have filed no draft offer document till the day the issue closes, the offer closes. During this period, people, if any promoter or promoter group, if they have made any transaction in the securities, meaning from the day you have filed draft offer document to the day the offer is closing, in between this period, if at all the promoters, if at all they have done any transaction in the securities, meaning if you have purchased or sold, you have to report it to the stock exchange within 24 hours. Why? This is to avoid people doing something behind the back. Because in all the prospectus and all, you would have given promoter shareholding as 60%. But after filing the draft offer document, now if you're selling it privately to someone else, you're not supposed to do. That's why they're telling you, if you do it also, you have to disclose. Any pre-IPO or pre-offer placements disclosed in draft offer document. So before IPO, if I have made any issues to anyone, I have to disclose it to the stock exchange within 24 hours. I hope you understood this scenario. I have given my draft offer document. Before that only, if at all there is any trade made, if I have given it to the promoters or any pre-IPO, before IPO, if I have made any private contracts, I have to disclose. Yes, sir. The next one is rights issue eligibility. Issuer must meet all the chapters at the time of filing draft letter of offer and filing letter of offer. Now 50 crore limit is removed. Rights issue, a new non-eligibility condition has been introduced. What is that? A issuer cannot do a rights issue if its equity shares are suspended as a disciplinary measure. Rights issue not possible if at all you were suspended in the past. Change in terminology. Draft offer document should be read as draft letter of offer when you are reading it for rights issue. See, for IPOs, you use the word called draft offer document. For rights issue and all, you will use the word called as letter of offer. Filing process changed. The draft offer document, first we had to file it with SEBI, no. Now they're telling you, going forward, you don't have to file draft offer document with SEBI. Then whom should we file it with? They're telling you, do one thing, file it only with the stock exchanges. Only for observation people. See, you will file only with the stock exchange. If at all there is anything that is just for information, you will file it with the SEBI also. But the approvals and all you will be taking with the stock exchange only. Not with the SEBI. That has been relaxed now. Just 1 second. Yes, sir. Just a second. Okay. So see, draft offer document has to be filed with SEBI for observation. Now it is stock exchange. SEBI only receives a copy for information. That's a change. Okay. Also, we'll have to give PAN of all our promoters who are individuals, even body corporates. If they are our promoters, we have to give the PAN of that also. And we have to give due diligence certificate. Nothing but all the verifications, all the claims are perfect. So it's a due diligence, meaning a certificate given by a professional that there is no nothing to worry in this company. Okay, rights issue, willful defaulters. What do you mean by that, sir? If issuer or any promoter or a director of a company is a willful defaulter or fraudulent borrower, if this tag has been given to you, willful defaulter or fraudulent borrower, then people, such promoters cannot renounce their rights. Rights issue, renunciation is there, no. They cannot renounce it to anyone else, but they can renounce it within the promoter group, or they can renounce it to the specific pre-disclosed investors. Who are those pre-disclosed investors? Let us imagine before we filing the letter of offer, that time only we have clearly given, sir, we will be doing a trade My share may be given to this person B. We have already disclosed this list to the stock exchange. To them we can do. I can renounce it in the favor of them, even though I am a willful defaulter or a fraudulent borrower. Remember and go this. Appointment of intermediaries. Intermediaries must be SEBI registered. There is no change. Issuer must enter into a formal agreement with them. This is no change again. Merchant banker is no longer mandatory for rights issues. Earlier for every issue merchant banker was mandatory. Now not mandatory is what they are telling you. Bankers to issue appointed as per schedule. Registrar must be SEBI registered plus connected to depositories as per deemed agreement with the self-certified syndicate banks. Same procedures will apply even for rights issue as well. Nothing again changed. Nothing more, nothing less. Disclosure requirements. Draft letter of offer contains all material disclosure, have to be true and adequate, have to follow the schedule, contains financials not older than 6 months from issue opening. So I have to give you recent financials. I also have to disclose if issuer, promoter, director is willful defaulter, fraudulent borrower, credit of right entitlement in demat and renunciation process. There is nothing but I have right? That I have to intimate that in your trading account, the right entitlement has been now credited. If you guys want, you can keep it, or you can renounce it, or you can sell it, as the case may be. And what is the renunciation process? We have to clearly give this to you. Disclose. Filing requirements. We file draft letter of offer with stock exchange, letter of offers also with stock exchange, but SEBI we will give intimation. Public availability of LOF. Available all required websites which saw stock exchange provides copies to the public. Versions must match those filed with SEBI or exchange. So if I maintain something on my website, it should be same as whatever is filed with SEBI also. It should not be different. Deciding the issue price. Fix issue price before issuing the record date in consultation with designated stock exchange. Issue price have to first be fixed before the record date. Record date is what? The book closures. Before that only have to come up with the issue date. Okay. Removal of employee reservation. You remember, for us it was not there anyways. In old syllabus it was there. If a company is going for an IPO, people, they may reserve for the employee category. Employees can participate in your IPO, no? They can reserve up to 2 lakh rupees, which was extendable up to 5 lakh rupees. Now this entire thing has been removed. So there are no limits now. You can reserve that for your employees. Next one, letter of offer. Every application form must be accompanied by a copy of letter of offer. Availability of issue materials. The letter of offer should be available at stock exchanges, registrar and transfer agents, depository participants, stock brokers, bankers, investors association, self-certified syndicate banks, all your banks. And letter of offer shall be sent to all shareholders at least 3 days before the issue opens. This is what is given in Companies Act, people. If you remember, we give you a letter of offer today. The offer should open at least 3 days after giving you the letter of offer. Yes, allotment to specific investors. Specific investors, those whose names are pre-disclosed under Regulation 84, they must apply at least on day 1 before 11 a.m. Issuer must inform stock exchange by 11:30 a.m. These application cannot be withdrawn. Now what are these people? Nothing but, let us imagine whenever a company is going for an IPO, there are a certain specific investors. Let us imagine anchor investors. They're telling you, you guys have to apply for IPO. If you guys are applying, you have to apply it on day 1 only. That too what? You have to apply before 11 a.m. itself. Certain specific investors, who are they? They have given in the new regulation called 77B, not there for our syllabus. So they have to apply before day 1, before 11 a.m. and that entire thing has to be disclosed to the stock exchange. Whoever has applied, this has to be disclosed by the company to the stock exchange by 11:30. Sir, these anchor investors have invested in our company. By 11:30 have to give a report. For other categories of specific investors, application money must be submitted before the base of allotment finalization. Meaning for other categories, you have that 3 days time. For, whatever is the offer period, you can apply during that time. Removal of underwriting requirement. Underwriting requirements is no longer required now, it seems. Lead managers no longer required to undertake minimum underwriting obligations as earlier. Earlier, people, if you remember, in certain IPOs, whoever is your lead manager, he had to mandatorily do some minimum underwriting as well. Now that condition has been removed. Monitoring of issue proceeds, if you remember, people, credit rating agency, earlier it was not required. Now they are making it mandatory for all rights issues. Whether 50 crore anything, it is required. Opening of rights issue, opening period of rights issue shall be as per Companies Act. It is nothing but, people, minimum period is 7 days, maximum period is 30 days. Subscription period, that is as given in the fast track rights issue. Now this has been removed. Eligibility condition and procedure for fast track rights issues are now deleted or omitted. Earlier we had fast track rights issue, that entire thing has been now deleted. So technically there are some amendments, people, under rights issue as well as under some public offer. Rights issue part alone, remember, you can expect some 3 marks question maximum, if at all they're asking. Clear? That is the one thing. September, what is this? Okay. SEBI has notified the SEBI issue and listing of non-convertible securities which will come into force. And it says a new definition of environment, social and governance debt securities, also called as ESG debt securities, is inserted, which means a green debt security, social bond, sustainability linked bonds, or any other type of bonds by whatever name called, that are issued in accordance with such international frameworks as adapted or adjusted to suit Indian requirements that are specified by board from time to time. An issuer desirous of issuing and listing ESG debt shall comply with the conditions. Regulation 26 pertaining to issue of green debt securities is omitted. So this was there, this has been omitted. Now a new thing called as ESG debt securities are now been introduced. What is that, people? Nothing but this green social bonds or green debt securities is nothing but, now imagine I'm raising money, I'm raising debt only, but if at all I'm raising debt for betterment of environment, I'm doing it for say solar energy, now I will come under ESG debt because I'm doing environment friendly business, right? So if I'm raising money, anything for that, now that is called as what? ESG debt. That is what they have added. Okay. Okay. Okay, the next one, people, they have made some amendments, people, in LODR. Now, what is this LODR amendments, people? If you ask me, out of all, the important amendment has happened in LODR. Meaning, if you guys think that, sir, these amendments and all, why, sir, for me, then it's okay, directly focus on LODR amendments and go. Getting the point. Now what does that amendment say? Easy only. Wherever I'm telling you important, no more. And so LODR, they're telling you the first amendment, people, secretarial audit and secretarial compliance report. Now what is this amendment, people? Simple. If you guys remember, in your Companies Act, you would have seen something called as rotation of an auditor. An individual auditor can be appointed maximum for a period of 5 years. If at all a firm is appointed, then 5 years, 2 tenures. If you want to reappoint both of them, there shall be cool off of 5 years. Same thing will now, people, apply to secretarial audit as well. A secretarial auditor, tenure limits have been added. What is that here? An individual can be a secretarial auditor maximum for 1 term of 5 consecutive years. If firm, 2 terms of 5 consecutive years. That too with shareholders approval. That is reappointment. If you want to be reappointed, cooling off of 5 years is there. If there is any casual vacancy in secretarial auditor, it should be filled within 3 months. Now, that is one amendment. Amendment number 2. What is that? Now, going forward, who can take up secretarial audit? SEBI requires that secretarial auditor to be a peer-reviewed company secretary, not an ordinary company secretary. Now, what do you mean by peer-reviewed company secretary? Simple people, you guys see this concept in CS final, in professional level. What do they say? Imagine people, there are two CS, CS1 and CS2. Now, what is the guarantee that people, the CSA, his work is really going good? Now, he is doing so many audits, he is doing so many works. What is the guarantee? His work, his way, his working style, the way he is auditing, the way he is maintaining the documents, everything. What is the guarantee that all of this is fine, fair, correct, true, accurate, competent? What is the guarantee? So, our ICSI says people do one thing, get your books checked by another company secretary of the same profession technically. He will come and review your book, you will work, whatever audits you have done, whatever documents you have maintained, whatever the way you have done your work. I will check all of that, I will review it and I will give you some report. If I give you a clean report, now I am called as what? Peer reviewed company secretary. Meaning, my fellow mate has recognized that my work is good. Only the people whose work is being recognized by the peers. Peer means what? Competitors or of the same status. Whoever has been peer reviewed, only they can take up a secretarial audit. Not only that, only they can take up a secretarial compliance report also. Secretarial audit, all the laws. A compliance report, only SEBI related laws. That is the amendment. Amendment number 2. Clear? Done. Next one, sir. Compliance officer seniority whole time. Okay, now what do you mean by that, sir? A compliance officer from today people, they have clearly written this person should be a whole time officer. Till today we always said a company should have a compliance officer. So that person could have been a part-time officer also. Nowadays, now it is going forward simple. It should be a full-time officer. And remember, not more than one level below the board, and this person should be designated as a KMP. Only such people can be appointed as a compliance officer. In a company, there can be 5 company secretaries people. Not all the 5 company secretaries are KMP. Remember, the misconception we have. Only the company secretary who is called as KMP will be KMP. Generally, these people who will be called as KMP will be a senior company secretary. Are you getting the point? Now that is what they are telling you. Going forward, a compliance officer should be a full-time member and you should not be more than one level below the board, and you should be called as a KMP. Only they can be appointed as a compliance officer. And if there is any vacancy in their position, it should be filled within 3 months. For companies under an approved insolvency resolution plan, a vacancy must be filled within 3 months of the plan approval, and at interim, there must be at least one full-time KMP managing day-to-day affairs. What do you mean by that? A person undergoing insolvency resolution process. For them also, there has to be one compliance officer. If there is any casual vacancy, you have to fill it within 3 months. 3 months from when? From the day your resolution plan is approved. So the resolution plan can take 6 months, 10 months. Whenever it is approved, from that day within 3 months I have to apply. I have to have one compliance officer. So till then, at least have one full-time KMP with you. More than sufficient. Anyone, but have one full-time KMP with you. This is the amendment. Clear? Next one, related party transaction. Now what is a related party transaction, sir? Simple people. Now they have excluded 2 things from the definition of related party transaction. What is that? Now people, SEBI clarified that the retail purchases by directors or employees from the company. What do I mean by that? Now for example, I am a CS of Tata. I went and I purchased Tata car. Now is this allowed? They're telling you people that is a retail business, meaning there should be no other business relationship and it should be uniform. However, you're giving it to all the other directors, all the other officers. If you're treating me in the same way, no special treatment, then people, what we are telling, we will exclude such transactions from related party transaction, which is in the ordinary course of business. Now, Tata company products, now, for example, I'm a Reliance company employee. I have Reliance Jio. I'm buying their product, then I should not buy. Yeah, that's what they're telling you. Next one, people. Let us imagine I'm a ICICI Bank. I'm an ICICI Bank employee. I have my what is that? Probably my bank account with ICICI Bank only. They're telling you it's okay. And any interest that is coming on that is also okay. It will not come under related party transaction. So these two are excluded. Any ordinary business relationship and your bank accounts excluded. Clear? Next one, remuneration and sitting fees paid to directors, KMP, senior management need not be approved by audit committee if immaterial. Going forward, any sitting fees or remuneration paid to these people, if it is immaterial, we need not pay it. I mean, we need not approve it by audit committee. Next one, independent directors on the audit committee may ratify certain related party transaction within 3 months who independent directors, provided the aggregate during the financial year is less than 1 crore and not material, and reasons for not getting prior approval are recorded. Failure to ratify may render transaction voidable and directors involved may have to indemnify the company for the loss. Audit committee may grant omnibus approval with quarterly review. Now, what is this, sir? Now, imagine people in any related party transaction meetings. I was not party to it and the company has not taken any approval. Now, what they're telling you people, the independent directors, if the company has done any related party transaction, we may still ratify it within 3 months, it seems, even though they have not taken the approval, provided the transaction is not more than 1 crore and it should not be material transaction. Understood? If I do not take this ratification, if you do not take independent director approval, then whoever are the directors who entered into a contract, they will be personally liable. Correct? Omnibus approval definitely possible, which we have seen also. Next one, investor grievance reporting. This is nothing but they have come up with a standardized format. So based on investor grievance reporting, how many people have filed their investor grievances, meaning complaints received during the time, and how many were resolved, how many were not resolved. So complete status, we have to file it as a standard report. This is filed quarterly. That is not much important. Faster board decision disclosure and digital access to annual report results. What is this? Okay, simple. Now let us imagine people, there was a board meeting. In the board meeting, they have conducted some important decisions which we need to disclose it to the stock exchanges. Correct? We have to disclose it to the stock exchanges. Regarding that, they have come up with a procedure. When should we disclose it to the stock exchange? They are telling you, SEBI added the tight timelines. If board meeting ends after market hours, that is, let us imagine, if the market ends at 3 o'clock, let us assume, if the market is ending at 3 o'clock, if the board meeting ends after market hours, but more than 3 hours before next day, disclose the decision within 3 hours. Annual report must be published on the website. Okay, now let us try to understand what do you mean by this. I've given an example. Let us imagine a company conducted a board meeting and the meeting ended after the market hours. That is, let us imagine it ended on 8 p.m. When will the market open? 9 a.m. Sir, when did the meeting close? 8 p.m. When will the market open? 9 a.m. What is the gap between 8 p.m. and 9 a.m.? Definitely it is more than 3 hours. That is what they have given here. it is more than 3 hours, then they are telling you this is more than 3 hours, so the company must disclose the board decisions within 3 hours. So if the gap between the conclusion of the meeting and the opening of the stock market, if the gap is more than 3 hours, you have to intimate within 3 hours. Sir, what if example 2, less than 3 hours before the market opens? What do you mean by that? My board meeting ended in the morning 6:30. The market opens at 9. Now the gap is less than 3 hours. Then the rule says people, you have to intimate as soon as possible. So if the gap is more than 3 hours, intimate within 3 hours. The gap is less than 3 hours, then you have to intimate as soon as possible. When can this happen? Why will someone conduct a meeting morning? People, what if meetings are conducted in some other place? The time zone difference can be there, right? Yes, it can be there. People will have night meetings also. Because if a big company is there, that means what? There can be any time, because even the foreigners also have to join. Yes, sir. Next, Amendment Regulations 2025. They've added something called as HVDLE. What do you mean by HVDLE? High value debt listed entities. Now, what is the amendment? Simple, people. Generally, when we say listed company, we do not take a debt into the consideration. Now what we are doing is we are also adding the debt into the consideration. That to which debt? Only the high value debt. But what do you mean by high value debt? They are telling you SEBI introduced a chapter applicable to entities with only listed non-convertible debt securities outstanding value of 1,000 crore or more. They introduced one chapter. Now it should have an optimum combination of executive and non-executive directors. Same cut, copy, paste. Whatever scenarios you guys would have seen for listed company. Same cut, copy, paste will apply. What do you mean by that? What if the chairman is the chairman of the company is a executive director? Then in such case, what do we do? Then people, they're telling you, where is it? Optimum combination of executive and if the chairman is an executive director, then more than 1/2 of the directors has to be independent directors. What if the chairman is a non-executive director? Then people, 1/3 of the directors has to be independent directors. Correct, huh? Yes, huh? And what is one more thing? Independent, this one, women director provision will also apply. Now see, they would have given that also. Such companies will have at least one women director also on the board. Same thing will apply to listed companies also, no? But here remember, they have not written as independent women director. They have written as women director. Okay. And not only that, you remember how many companies a person can become maximum director of? It can be 7 listed companies. In that, this is also included. A person can be an independent director of 7 listed companies. This is also included. If I am already a managing director or whole-time director in one company, and then I want to become an independent, I want to become an independent director, then I can become maximum. In one company MD, in maximum 3 companies, I can become independent director. Same cut, copy, paste will apply to the companies who have listed their high value debt, meaning 1,000 crore and more. Clear? The company should also follow the following committees: audit to NRC, SRC, RMC. And not only that, they should also form a whistle mechanism. So same thing, see, cut, copy, paste will apply. Not on everything will apply, people. If you remember, the company shall formulate a policy on materiality of related party transactions. Materiality. And which shall be reviewed once in every 3 years. Provided that a transaction with a related party shall be considered material when the transaction to be entered individually or taken together with previous transaction during a financial year exceeds rupees 1,000 crore or 10% of the annual consolidated turnover of the listed entity. What do I mean by that? A company is entering into a contract with its director. What is the value? They're telling you if the value is more than 1,000 crores. Let us imagine we are entering into a contract of 1,200 crores. This contract will call as material related party transaction. Technically, you have to take value of more than 1000 crore or 10% of the annual consolidated turnover, meaning this listed company, its subsidiary company, its associate company, take all its turnover. Let us imagine if all its turnover is coming to 6,000 crores. What is 10% of it? 600 crore. 1200 crore or 600 crore, whichever is less. If a company is entering into a contract with its related parties for this value or more, if you are entering into a value for this, then they're telling you what, people? It will be considered as what? Material related party transaction. Understood? Hello? So, if at all, let us imagine the moment I touch 601 crore, this becomes material related party transaction. Whichever is lower, exceeding that, it is a material related party transaction. Clear? One more, see, at least one independent director on the board of high value debt listed entity shall be a director on the board of director of unlisted material subsidiary, whether incorporated in India or not. What do I mean by that? Now imagine, sir, I am a listed company which I have listed my high value debt. Now, sir, I will have one independent director, no? Now imagine if I have so many subsidiary companies, company A, company B, company C. They're telling you at least one independent director should be a director, whole-time director of a subsidiary company. I should be a whole-time director of a subsidiary company. When if this subsidiary company is a material subsidiary company, we would have seen this materiality and all these concepts in your normal class only. Same cut, copy, paste scenario will apply to them also. Understood? Pakana, the 20% criteria and all you would have seen. So whoever is the independent director of this entity should become a full-time director of this subsidiary company. Which subsidiary company? Not every subsidiary company. The material subsidiary company. Whether this company is in India or not. That is what they are telling you. Hello? Done? Done. Every HVDLE and its material unlisted subsidiaries incorporated in India shall undertake secretarial audit. Every HVDA, for them also secretarial audit applicable, and all its subsidiary companies which are incorporated in India, even for them the secretarial audit is applicable. Remember, important. You always do it within 60 days of end of financial year. You have to submit not only secretarial audit. They see what does it say. Come in such form. Every HLD shall submit a secretarial compliance report in such form as may be specified to the stock exchange. Now, what do you mean by that, people? For all these companies, secretarial audit report is also applicable. But for this company, secretarial compliance report is also applicable. So, for the company which has issued the debt, for them secretarial compliance. For everyone else, secretarial audit is also applicable. Remember and go, important. Next one, sir, SME exchange. If outstanding crosses the threshold mid-year, then ensure within 6 months. So, for example, for someone, they cross it mid-year. This turnover and all, they have to, follow the rule within 6 months. And once applicable, it is applicable for 3 years. Next one, people, SME exchange, a related party transaction applicability and materiality threshold for SMEs. What is this, people? Nothing but from April 1st, 2025, the regulation 23, that is nothing but related party transaction, will start applying to the entities which are listed on SME as well. Provided who has a paid up capital of more than 10 crore or net worth of more than 25 crore. Any one condition to be satisfied. So, if at all your paid up capital is more than 10 crore, your net worth is more than 25 crore, then people, such SME companies should also follow related party transactions. Okay. And effective April 1st, 25, in case of listed entity which has listed its specified securities on SME exchange, a transaction with a related party shall be considered material. If the transaction to be entered individually or together in a financial year exceeds 50 crore or 10% of annual consolidated turnover, whichever is lower. Whatever we saw above was 1000, no, here it is 50 crore or 10% of the consolidated turnover, whichever is lower. So if we are doing any transaction with the related party, we will consider this particular transaction as material. Understood? Yes, that is what they have given here. What if it's material, people? Nothing but you will take more approvals. The procedure will be different. Again, same thing, people. In mid, if it is applicable, within 6 months you have to comply. Once applicable, 3 consecutive years it is applicable. The next one is called as what? Scores registration. You remember, people, every entity will now have to take scores registrations with SEBI, that we have seen also. Now, earlier what used to happen, people, imagine there used to be a lot of special purpose vehicles. There used to be one trustee. Now, imagine, if you remember, I told you, right, that asset reconstruction companies, they will purchase a non-performing asset from SBI and they will group that as a different asset. They will purchase NPA from Axis. They will group it as a different asset. Like that, people, they used to form different entities for different assets performed from different banks. We have purchased from SBI. We will form this as one special purpose vehicle. Once we sell all the NPAs taken from SBI, we will close it. Now we have taken NPAs from Axis Bank. Once we, collect all the NPAs, we take our money, we realize it, we close it. Like this, one trustee used to have more than 100, 200, 300 special purpose vehicles under them. Now, as per scores registrations, everyone had to get registered under scores. Unfortunately, waste of registration, waste of time, because everyone will be overseen by trustee only. Now, what they have done, they have said no individual registration is required for the special purpose vehicles. Do one thing, let the asset reconstruction company alone get registered, that is sufficient. Under scores. That's the amendment. Done. That's all. This is what is given under your LODR. LODR is a major one that was there. Rest is absolutely manageable. Okay, next one is prohibition of insider trading. Very minute one is added. See, this connected person definition was there, no? In this connected person definition, there is a little change. What is that change, sir? Any person who has been during the 6 months prior associated with the company in any capacity, directly or indirectly, including by reason of frequent communication with its officers, or by being in a contractual fiduciary or employment relationship, or being a director, officer, or an employee of the company, or holds any position including a professional business, whether temporary or permanent, with the company that allows such a person direct or indirect access to UPSI, is reasonably expected to allow such access. Now, what is that, people? Simple. There is no change, people. If you read this definition is now being replaced by this definition. There is literally no change, people. There is the 1 second, wait. Yeah, 1 second. Directly or indirectly, including a frequent commission, is a director of their employee position, including a professional business that allows such person directly or really expected to allow such access. Now, sir, what is that? Here they have added something called as, people. Where is that? this business relationship, professional or business relationship. This is there, check here. Was it there, business or professional? No, this was not the one. Where did that go? Mm-hmm. Okay, I'll just confirm you. There is this one change, people. This was the old amendment. They have been replaced this. I'm just trying to find out. There is one word that is added, people. Nothing else but that one word. Even if you actually go without reading, that also is okay. That is how much minor that is. Yeah. There is one amendment. Means whether temporary or permanent. Whether temporary or permanent. I think I've changed it. I think I've changed and put the amendment. I'm so sorry. Yeah. Okay, then this is the amendment. Yeah. Technically, people, you will be finding this connected person. Now that they have replaced one particular word. I'll try to see it. Now, if you guys find it, if you guys put it in the comment box. If not, I'll only tell you what is that particular word. I think I must seeing that. Okay. Now, sir, what else is the next amendment? They have said next amendment is, people, the word immediate appearing in point A and J to regulation 2(1)D is omitted. The word immediate. Now, where is that immediate? 2(1)J. See, A, immediate. And next one is J, there will be immediate. Where is that? One more place. Where is that immediate? Immediate. So wherever the word immediate relative was there, now it is replaced by the word relative. Now what do you mean by the word relative? Immediate relative was defined. What do you mean by the word relative? They have added new definition. The word relative means this. What? It means spouse of the person, wife or husband, parent of the person. So imagine if you are seeing from the husband's point of view. So wife, parent of the person, that means mother and father, parent of its spouse, that means father-in-law and mother-in-law for you, or the wife's mother and father, sibling of the person, let us imagine a sister or a brother, sibling of the person and sibling of its spouse. Your wife is there, the wife ka sibling, okay, child of the person, so your children, and child of its spouse. Imagine this can happen in divorce cases, second marriage, their child also your child. Spouse of the person listed at subclause 3, meaning subclause 3 is sibling. So siblings, spouse, wife or husband, and who else is there? Wife ka sibling, their spouse. Okay. Spouse of the person listed at subclause 4. Who is listed at 4? Children. So your children, their wife or husband, their wife or husband. Now this is the definition of relative. They have added this. Simple, huh? Okay. Next one. They have said people what and all is considered as what? Unpublished price sensitive information. They have defined something. According to the notification, following information are to be included in the definition of UPSI. Now all of this is considered as unpublished price sensitive information. It seems what? Merger, demerger, acquisitions, award or termination or order or contracts not in normal course of business. What do you mean by that? We had a contract, our biggest vendor. That contract has come to an end. Or imagine, award means what, people? Let us imagine we are fighting one arbitration case. Now that has come to an end. Next one, changes in KMP other than due to superannuation or end of term resignation. Meaning, what is that? You changing changes in KMP other than due to superannuation or end of term. Meaning KMPs, if at all they are coming to an end, based upon if we have appointed them for 5 years, the 5-year term is done, that is okay. But if any other case, if they are coming in, going out, you have to intimate. That was already there. For that they have added even if statutory auditors are resigning, secretarial auditors are resigning. Now this is also called as what? UPSI it seems. Earlier KMP was already there. Now this and all is as it is there. This is not changed. Only the one in bold has been changed. Change in rating other than ESG rating. Whatever ratings are. Credit rating. Fundraising proposed. IPO, FPO. Agreements by whatever name called. Meaning, imagine joint venture agreements, shareholder agreements. If you guys enter, that is also UPSI. Fraud or defaults by company, promoter, director, KMP. If you guys have done frauds, that is also considered as UPSI. Because if it goes outside, it will have an impact on the market, right? News. Resolution plan or restructuring or one-time settlement in relation to loans or borrowings from banks or financial institutions. Nothing but people. If you guys are entering into compromises before world knows, you guys only are doing it. It's a bad news. Admission of winding up petition filed by any party, creditors, application tribunal, initiation of corporate intro, nothing but people, IBC, insolvency is going on. Initiation of forensic audit, meaning serious audit. Action initiated or orders passed within India or abroad by any regulatory or statutory enforcement authority or judicial body against the company or its directors, meaning nothing but people. Someone has initiated a legal proceedings against you. Outcome of any litigation, meaning a fight was going on. That outcome has come. UPSI. Giving of guarantee or indemnity or becoming a surety by whatever name called for any third party by the company, not in the normal course of business. You're going and giving a guaranteed transaction for someone else's loan. Granting withdrawal, surrender, cancellation, suspension, key licenses or regulatory approvals. What are those people? Imagine our FSSCA license is taken back. Our franchisee agreement has come to an end. Our royalty agreement has come to an end. All that will come here. Entry of information not emanating from within the organization in structured digital database may be done not later than 2 calendar days from the receipt of such information. If you remember, what is this? A structured digital database. If you guys are sharing UPSI with anyone, you guys will maintain it in one record. If it is coming within the company, you guys will maintain everything within, as soon as possible. But if the information is emanating from outside, someone else is doing something, but the impact is there on you, meaning someone is filing a case on you. That has to be written, made a note of within 2 calendar days. That is what they're telling you. Next one, here there is no amendment and no amendment. The only amendment that is there now is in the last one is mutual funds. That's the last amendment, sir. Mutual funds. Yay, we are almost done. Now, people, what is mutual fund amendments, sir? Simple amendments, people, nothing major and all. I'll tell you important, concentrate. Not important, okay. Changes relating to application rejection. Now, what is it, sir? You remember who will start a mutual fund? Sponsor. Now, people, they are telling you, now, whenever a company that is a sponsor, a SEBI can reject an application for registration as a mutual fund if the application is not complete or does not comply with SEBI requirements. So there was no explicit mention that if the sponsor does not meet the eligibility condition under regulation 7 or 81, SEBI can reject. Now what have they done? Regulation now expressly states if sponsor does not meet regulation 7 or regulation 81, SEBI may reject the application. So simple, people, earlier they had not specifically written that sponsor, if you do not meet the eligibility criteria, we will remove your application. We will reject your application of mutual fund. We had not expressly written, but we used to still do it. Now we have expressly written. If you do not meet the eligibility criteria, you cannot start a mutual fund. Same thing for AMC also. It was not expressly written that if at all your application is incomplete or if you do not satisfy, then you will not be able to form this AMC or mutual fund. Now we have specifically written. If an AMC does not meet regulation 21 or does not meet regulation 86, that is nothing but people. This says requirements, this says net worth. Then SEBI can reject your approval. Okay, important. Regulation 29A. This may be important. What is that with regards to nomination? What is that? Earlier people regarding these things, there was no clear rule. Now there is a clear rule. Now people, after death, you have to now nominate now while you are alive. Who will be your nominee after your death? You have to clearly nominate it. Till now it was optional, now it is mandatory. Nominee for incapacitation. What do you mean by that? If you meet with an accident, you become unsound mind, you become ill. In that case, who will manage your account? You have to, you have to appoint a nominee, mandatory. In the case of joint shareholders, together you guys have to nominate one. If both of them die, this person will get the rights. AMC or RTA, not liable. Meaning what? If they have acted as per this, the asset management company or registrar and share transfer agents, they are not liable for if they have complied according to whatever you guys have done. Their liability will come to an end. Remember and go. This is something which they have added. Next one, they have added something called as specialized investment funds, SIF. May be important, 3-mark question. Now, what is specialized investment funds, people? Nothing but these are high risk funds. So it is not for everyone. So what mutual funds, it's a new scheme. So it's a high risk funds. So what did the mutual funds started doing? They started doing the trade in these mutual funds along with people, their regular mutual funds. Imagine I open ICICI mutual funds. I see all their schemes. No, there only this scheme is also there. So people who come here, they used to attract towards this scheme. They said going forward, nothing doing. These high schemes, it should not be for everyone. It should be only for a specific category of people. That is people, imagine in this fund, if you want to invest, the minimum investment is 10 lakh rupees. Whereas in a normal mutual fund, you can invest even 500 rupees. So it is not for everyone. And remember, for this, you have to do a specific different rebranding. It should not be visible in the same website so that people do not fall for it. They should know it's risky. That's what is given. This is a completely new type of scheme category introduced by SEBI. What is a specialized investment fund? A high risk, flexible, strategy based category inside the mutual fund structure for wealthy investors. It's an alternative style for investment model. See, rule 1, minimum investment of rupees 10 lakh. That's the minimum investment you have to bring in. Except if you are an accredited investor, that's a license you work under. If you are an accredited investor, then this minimum criteria is not applicable for you. Rule 2, types of strategies allowed. It can be open-ended, close-ended, and even any other way of schemes. 20% cap per issuer. What do you mean by that, sir? Now, mutual fund, they cannot invest more than 20% in a single debt. Single debt means what, people? Let us imagine Adani has issued debt instruments. So the entire money we have raised is 100 crore. We cannot invest more than 20 crore in a single company. There is a cap. We can increase this to 25 crore if your trustees and your asset management company agree. You can increase this 20 to 25. That is this. Rule 4, separate branding and identity. This is what I told you. There has to be a separate website, separate marketing, separate identity and separate branding. You cannot mix it with your regular one because we do not want regular people to get tempted. Responsibilities of trustee. AMC has to be an expert. AMC maintains internal controls and risks, and you have to follow SEBI disclosures. It is your duty. Responsibilities of trustee. Offer document risk requirements clearly have to highlight it's a high risk investment, and have to give all the details about the disclosures and have to follow SEBI norms. Here, and they've added one more thing, sir. The last thing people called as mutual fund light. What even mutual fund light means, people? You can imagine like this. There is a mutual fund. There is mutual fund light. This is an active investment scheme. This is a passive investment scheme. Here, investment decisions specifically happen. They use their brain. Here, nothing, people. This is like a passive investment scheme, meaning they don't use their brains. They just follow already existing funds. Like, people, we follow Nifty schemes. We follow Bank Nifty. We follow this IT Nifty. Done, huh? Just give me 2 minutes. 4:15 the class has to start. Huh? Is it 2 minutes I have? Huh? Okay. Huh? Just give me 2 minutes. The present regulatory framework for mutual funds provides for, now what happens, people? For them, higher and stricter regulations are there. For them, people, because it is convenient, it's passive schemes, and they are not doing anything risky, and because of that, people, the regulatory requirements, the entry norms and all of that is flexible. That is what is given here. Now see here, passive funds allow a rule-based investment strategy, and there is negligible discretion with AMC. You don't do any choices regarding the asset allocation and investment objective. As such, various provision of existing regulatory framework may not be relevant for passively managed scheme. So it's a passively managed scheme. Accordingly, SEBI has made amendments to the SEBI mutual fund regulation and inserted a new chapter 11, mutual funds light, for enabling a relaxed framework with light touch regulations. We do not have strict regulations for them. For whoever are the entities who wants to launch only this passive mutual fund scheme, you can do it. Mutual fund light means a mutual fund that has obtained registration and is having only such index funds, exchange traded funds, ETFs, fund of funds or other mutual fund schemes as may be specified by the board from time to time. Only these schemes you can run. See, that's what I'm telling you. Exchange traded fund, index fund is what? Nifty fund, Bank Nifty, ITBs. I'll just follow that. I will not use my brain again. The light touch regulation include relaxed requirements relating to eligibility criteria for sponsors. For a mutual fund, it's stringent. For them, it is lenient. Net worth, lenient. Track record, profitability, responsibility of trustees, approval process, disclosures. All these things are lenient for them. The framework intends to promote ease of entry. People want to come. More and more people wants to start this. Encourage new players. Reduce compliance requirements. Increase penetration. Enhance market liquidity. So that more people, they raise more funds. That's what is the intention. And the last one, sir, it's called as, people, last two, employee remuneration and stress testing. There is one thing that they have added. What is this, people? Now, asset management companies, people, they have to mandatorily do one thing. What? Now, asset management company will have employees working in that company. Now, you guys are investing the money in mutual funds. Now, what if this fails? You guys have nothing to lose. Now, there is a rule. Whatever the employees that are working for you, AMC, you have your employees, no? You guys have to invest a little percentage of their salary in the mutual funds you guys are operating. So that if this fails, you know that your entire system will collapse. That is what is called employee remuneration to be invested. Mandatory going forward. The next last one people is called as mandatory stress testing. What is this people? Now till today people, for all the debt schemes, the stress testing was optional. Now it is mandatory. What do you mean by that people? Now example people, now I have invested 1 lakh rupees in my mutual fund. If this all of a sudden collapses, imagine it becomes 50,000. How would I react? How would the company react? How would the employees react? Conducting this as a test is called as people stress testing. What if there is a market crash? What if any such things happen? How would we react? They will conduct some parameters. They will conduct a test. And the results can also be disclosed on the public domain. This is the last amendment. That's all people. These are the amendments. I wish you guys all the best. If you guys have any doubts, please let me know in the comment box. I'll be more than happy to help you all. Thank you so much for sitting patiently, and I hope you guys understood something out of it. And remember, whatever are the amendments made for June 2025, it is applicable for you. You guys can watch that only. Yeah, just these amendments keep in mind. Rest of it are the same. Thank you so much. See you all. Bye-bye.